This is Derek Sheriff, and you're listening to the Arizona 10th Amendment Center podcast. You're listening to the Arizona 10th Amendment Center podcast, declaring the sovereignty of the people and the power of the several states. Robert G. Natelson is a recognized national expert on the framing and adoption of the Constitution, and on several occasions, he has been the first to uncover key background facts about the Constitution's original meaning. He recently retired from the University of Montana School of Law, where he taught constitutional law, legal history, advanced constitutional law, remedies, and a seminar on the First Amendment. He's affiliated with two think tanks, being a senior fellow at the Goldwater Institute in Phoenix, Arizona, and a senior fellow in constitutional jurisprudence at the Independence Institute in Denver. He's written for some of the nation's most prestigious academic journals and publishers, and has 2 books out right now. The Origins of the Necessary and Proper Clause, a co-authored work published by Cambridge University Press, and The Original Constitution, published by the 10th Amendment Center. Barack Obama and the other supporters of unlimited federal power would like us to believe that we can't uncover the Constitution's original meaning. In essence, they're telling us that we don't have a constitution at all. Rob Natelson's new book, The Original Constitution, shows us that such a view is little more than a crock. The following is the book's preface read by Jeff Riggenbach, who is a journalist, author, broadcaster, and educator, and has also narrated the audiobook versions of numerous libertarian works, many of them available at Mises.org.
A Tavern in 1791. It is Thursday, December 22nd, 1791. You live in Philadelphia, currently serving as the temporary capital of the newly created United States of America. It has been only 15 years since independence was declared, and less than 3 years since the federal government began functioning under the United States Constitution. For a long time it had been touch and go as to whether the Constitution would be ratified at all. 2 states initially refused to agree, and of the remainder, 5 had approved the document only after the Constitution's supporters and moderate opponents had cut a political deal calling for a Bill of Rights. As soon as the new Congress met, 2 of the most important states, Virginia and New York, petitioned for a new convention to rewrite the Constitution. Only after Congress had approved the Bill of Rights did Virginia and New York abandon their petitions, and only then did the last 2 holdouts, North Carolina and Rhode Island, join the Union. The 14th state, Vermont, came in at the beginning of 1791. Earlier on this day you learned that the Bill of Rights had finally been ratified on December 15th. So now, you reflect, the Union is reasonably secure. Evening is approaching, and your workday is done, and you are on a Philadelphia street corner with nothing particular to do. The weather is chilly and blustery, but there is a cure for that, a warm punch in a cozy tavern. You enter the tavern and look around for a seat. The place is nearly full, but there is bench space at a long wooden table at one side of the room. Sitting around the table are men you recognize, eminently respectable men, some of Philadelphia's leading judges and lawyers. They are deep in debate about an abstruse point of real property law. Not being a lawyer yourself, you do not think of that sort of discussion as the key to a good time, but there are no other seats. You slip into the empty chair and order your punch while the discussion swirls around your head. Eventually, you decide to turn the conversation elsewhere. You give a little cough. The lawyers had barely noticed you, but now turn their heads and break off the debate. I regret that I feel unqualified to comment on your subject, you say, but gentlemen, you know I am not a lawyer. May I suggest another topic? They seem interested. The prior discussion had been wearing thin anyway. You no doubt have observed, you continue, that 10 new constitutional amendments were proclaimed last week. Yes, responds one of your listeners. You know him as a distinguished judge. They should work some change upon the system. That is exactly what I wish to pursue, you add. What is that system, and what change does the Bill of Rights effect upon it? The lawyers look at each other. One of them, he is particularly known as an expert in wills and fiduciary trusts, smiles. Well, my good man, that is an expansive inquiry whose response might consume some time. Are you otherwise engaged for the next few hours? The others laugh. But you press your question. It is only 7 o'clock. Your spouse has gone to Carlisle to visit relatives, and you are not otherwise engaged. Neither are you particularly eager to leave the warm tavern. I am at complete leisure, you respond. Please say on. The lawyers glance at each other. Well, why not? Asks one. As it happens, we are not engaged either. The courts are closed tomorrow, and our wives are enjoying the comfort of each other's society. I dare say that they have no present need of us. More laughter. I think I can speak for my learned colleagues here, the trust attorney interjects, when I tell you that there is no topic on which we would rather discourse than our new Constitution. We have exchanged views on this subject before, and we differ on the small points, but I flatter myself that we are in accord on the great ones. You are a bit amused at how easy it is to induce lawyers to talk. You draw deep from the warm punch and sit back and listen. What would those lawyers tell you that evening? What would have been their understanding of the scope of the new federal government and its powers? What would they relate of the role of the states or of the people? What, in other words, was the actual legal force of our Constitution as lawyers and intelligent laypersons understood it in 1791? This book answers those questions. The answers were important in 1791, but they are especially important today, when our federal government seems to have wandered so far from its roots. Those answers are deemed relevant to constitutional interpretation by almost everyone, and many people believe them dispositive. That is, many Americans, lawyers and non-lawyers alike, believe the Constitution's original understanding should govern us today. To be sure, some people, including the former law instructor who now serves as President of the United States, believe that it is impossible to reconstruct the Constitution's original meaning. As this book demonstrates, that view is substantially incorrect. Competent founding-era scholars largely agree on what most of the original Constitution's provisions mean. Much of the disagreement among constitutional writers results from unfamiliarity with the historical record, or with 18th-century law. We will never be absolutely certain of the complete meaning of every constitutional clause, but we can reconstruct most of the original Constitution's meaning with clarity and confidence.